Hey guys, Isaiah here at the Sportsman Shop.
And I'm Jordan. What's up, guys?
And today we're doing a video on gun trust. We have a special guest with us today, attorney Josh Bodine.
Thanks for having me. Appreciate it.
How's it going,
Thank
Josh?
you very much. Good.
And Josh, we just kind of want to pick your brain a little bit and educate our customers on what a gun trust is, how it will affect them when purchasing Class 3 items.
Absolutely.
So tell us a little bit about Carter and Bodine.
Well, at Carter and Bodine, it's our goal to be able to help anyone with a firearms issue. So whether you're a gun dealer dealing with the ATF or a sports club having maybe applying for a zoning variance, or even a private citizen just dealing with a criminal conviction, we can help.
So we're talking about gun trust today, kind of specifically. For somebody who may not know what a gun trust is, can you just kind of explain that a little more and go into a little more detail for us?
Well, a trust generally is simply an arrangement where you have a responsible person, that's a trustee, who is overseeing a piece of property on behalf of the beneficiary. You can have a trust for any item of property, real estate, whatever. So in the gun context, firearm context, essentially you're placing the Class 3 or NFA, National Firearms Act firearm into the trust. Trustee or more trustees are responsible for that, overseeing it, protecting it, access to it on behalf of the beneficiary.
Okay. And you mentioned the Class 3, the NFA item. What are some Class 3 items that you can put in a gun trust?
Well, the most common and those that are legal in Pennsylvania are your suppressor, also known as a silencer.
Right.
Short barrel shotgun, that's any shotgun that has a overall length of less than 26 inches or a barrel length of less than 18 inches. And I remember that because the 8 sort of looks like, barrel of shotgun,
Right.
Which is distinct from a short barrel rifle, which has a barrel length of less than 16 inches or an overall length of less than 26 inches. You also have your automatic, your machine guns, your fun toys essentially. Destructive devices, which would be grenades, those are not legal in Pennsylvania. But the short barrel shotgun, short barrel rifle, silencers, and your machine guns, those are all legal if owned properly in Pennsylvania and can be put into a gun trust.
We can't have fun with that.
Yeah,
That's
no
fun.
good. Yeah.
Not legally at least. It's a separate conversation.
Yeah, right.
Yeah.
So benefits to having a gun trust, as opposed to doing a setup as an individual. You know what I mean?
Yeah.
If I have a short barrel rifle and I want to do it as an individual, what are the benefits of me doing it as a gun trust instead of by myself?
So there are essentially 4 categories of benefits to owning an item in a trust format as opposed to an individual.
Okay.
Your privacy, ease of succession, asset protection, and what I'll call real-world practicality.
Okay.
So essentially, a trust is a private document, as distinguished from, say, a corporation where you have bylaws and articles of incorporation, things like that, that are filed publicly and really anyone can access that. With a trust, the documents remain between the trustees and the ATF.
Okay.
And so, and especially the way that I draft the trust, there's no bank that's involved, there's no third party that knows what items are in the trust.
Right, okay.
So you have a lot of privacy. Asset protection, that's really one of the hugest benefits. And one of the main reasons why you would get a trust as opposed to owning it in your own name. And what I mean by that is that, let's say you're sued for something unrelated to firearms. And now the creditor, let's say you lose and the creditor is coming after your stuff.
Right.
If you own the firearm in your own name, they can come after that. However, if the firearm is in the trust, of which you are a trustee, you legitimately do not own that firearm. The trust owns it. Think of it as its own person. And so there's a lot of asset protection consequences which would flow outward from that. You also have basically the real world practicality, and what I mean by that is that if you own a firearm in your own name, and let's say you're at the range with a buddy and they say, oh, it's an awesome silencer, never used one before, can I use that? You're going to have to be a jerk and say, I'm sorry, no, because you're running the risk that Officer Friendly, who may happen to be driving by at the time, may see that as a transfer that's going on between you and your friend, and that's a violation of federal law. If, however, the firearm is owned in the trust, there's a mechanism by which you can do a temporary transfer. It's not a transfer at all, actually. Name them as a temporary non-equity beneficiary, and it's a mouthful for basically saying, hey, while you're in my presence and I'm supervising, you can use this, provided that I know that you're not a prohibited person.
Right. What's the process on something like that? I mean, you said name them, so is that something we have to do?
Just a verbal thing you tell them?
Prior to, or?
Well, I have a specific form that you would fill out, give them a copy of, keep a copy with your own paperwork with you, so that it's a official above board thing. The fourth category essentially of benefits is that I would call them ease of succession. So in other words, if you own a firearm, an NFA firearm individually in your own name, and you die, your state's going to have to go through the Form 5 process to get it transferred essentially to another person, or even more complicated, let's say you're incapacitated, you're in an accident or for whatever reason you're incapacitated. There's a lot of red tape. It's certainly not impossible, but a lot of red tape that you're going to have to go through. If you have a trust format, then the succession is built in automatically. The way I draft it is such that if a trustee is incapacitated or passes away, there's an automatic process where another person will step in, and there's just a seamless succession there, and so it's just quicker and more efficient than owning it as an individual.
So do you guys facilitate all the paperwork as far as the trusts go for Class 3 items?
Absolutely. So essentially what a customer would do is come into the sportsman shop, talk to you guys about what they're interested in. Once they and you have selected something, they would come to me. We would talk about putting the trust together. Typically, once I'm hired, I would get a draft to the customer within 24 hours. My goal is to make sure that your customer, my client, has a document which they understand and which successfully achieves what they needed to achieve, so the asset protection and all the other benefits we've discussed. Once they've understood it and we've gone through that, which again can be very quick, or if they want to take more time, that's fine as well. But once we have the document, I'm a notary as well, so I notarize it. We have it witnessed. All the trustees come in. Like I said before, the bank does not have to be involved in the process. Some outfits, and I used to do this, open a bank account for the trust, but you have to have all the trustees come in, and that's a really problem, especially when you have out-of-state trustees. And so I've, in preparing and constantly trying to offer a better service for my clients, you can put any item of property in a trust. It doesn't have to start with a bank account. It doesn't have to be cash. You simply have to fund it in order for it to be a valid trust. So we typically use range bags. That initially funds the trust, sets it up. Once that's good to go, they bring it back to you guys. That is the trust document. You guys help them with the Form 4 and wait typically 4 months and wait for the item to come in and have fun.
And that's another benefit to having a trust is the wait period seems like it's a lot shorter.
Correct.
Like you said, 4 months is typical right now, is what we've been seeing. As far as individual setting up as an individual on a Class 3 item, I think for your suppressor it was...
Mine was over a year.
Yeah.
I mean, that was horrible, but it's down to probably around 8 months or individual.
Yeah, and that's pretty common, but yeah, you're looking about half that time if you're proceeding as a trust, because the ATF has realized this is a popular and effective tool, and a lot of people are using it, and they've gotten up to speed on that, and they're processing them a lot quicker than they used to be.
Right.
I think it's worth noting too, in a trust, you're not getting fingerprinted, you're not going through a lot of the hassles that have to happen as an individual.
Absolutely, and those are huge benefits as well, that with an individual application, you would have to get the chief law enforcement officer sign off. And if you happen to live in a jurisdiction where your chief law enforcement officer doesn't like your Second Amendment rights or just doesn't like the color of his shirt, forget it, they don't have to sign. Exactly.
Speaking for Isaiah, not...
Right. Sure. But there is legislation currently pending. Some folks have heard of 41P, but basically what that means is that the administration is trying to change that so the trusts would also have to undergo the chief law enforcement officer sign off and all that. That's not currently the case. And so that is a huge benefit to trust. But even if and when that changes, all of those other benefits that I mentioned will still remain in place. But this is an added benefit that we have, at least for the time being.
Yep.
Now, if the 41P does go through and you have a trust set up, do you then have to go through that process with the trustees?
I'm not in a position to
maybe
give
you
you
don't know.
100%
Yeah.
certainty, but my
Yeah.
understanding is that those who have already gone through the process will be grandfathered in.
Okay.
And
Okay.
therefore, they will not have to go back and do
Right.
that.
Right.
Can I tell you with 100% certainty?
Right.
I
Yeah.
can't, but that's the best information that I have, that as long as you are completed and in the pipeline, or in the pipeline at that point, you won't have to go back and redo it.
Mhm. That's something nice to know too, because if, you know, like you said, if your grandfather's in, you don't have to worry about it.
Correct.
Once you get it done.
Correct.
Yeah. That's nice.
One other question I thought of. So building a trust, how many trustees can you actually list on the trust? What do you normally see?
Sure.
I'm gonna ask the same thing.
There's no legal maximum. The legal minimum is that you have to have at least one trustee who's different than the beneficiary, because you can't hold something in trust for yourself, obviously. As a practical matter, I in my trust have set the cap at 10, and while that may seem initially to be a lot, the trusts that I do are perpetual trusts because of this ease of succession that I've mentioned. And so if you think on down through the generations, you could theoretically end up with hundreds of trustees, and you have an entity which is really far gone from your original purpose. So I capped it at 10. Certainly the fewer you start with, the slower it takes to get to that 10. I did a trust recently where we started off with 9. And so they don't have a lot of room for growth,
Right.
but when someone steps out, someone else can step in.
But like you said, with the ease of succession, if you have, say, 5 people, and those 5 people all have a beneficiary, that's technically when they step out of the trust or become incapacitated or whatever the case may be, that then is, they're added to the trust as a trustee instead of beneficiary, correct?
Yes, there's, if I'm understanding your question correctly, when a beneficiary, again, under the way that I've drafted it, when they turn a certain age and are of a certain maturity,
Yeah.
there's an automatic method and process by which they become a trustee.
Okay. Yeah.
And then when they step out of that beneficiary role into the trustee role, a new beneficiary would essentially have to be named
Yeah.
by consensus of the trustees. And so again, it's seamless and seamless.
Certain level of maturity you're in that.
Yeah, I think they made that.
It's
yeah.
gonna take you a while.
Close
You
your-
might make the beneficiary level, but not the trustee yet.
Yeah, yeah, it'll take me a little while.
Likewise.
All right, guys. Well, thank you, Josh, for
Thank you
being
very
with
much
us
for
today.
having me.
Appreciate it.
Appreciate it, guys.
And just tell our viewers a little bit about how they can get information on you guys.
Certainly. You can visit our website at carterbodine.com. You can give me a call, 669-0313, or you can just stop by. We're in Lidditz, 27 East Main Street on the 3rd floor of the Joe Boys building.
By the store, we are a Class 3 dealer, so stop by with any questions you've got. If you're looking for a certain item, we can probably hook it up. So stop by and come see us, and then we'll get you set up with Josh.